Are you fighting for sole custody in Wisconsin and not sure if it's even possible? Many parents believe Wisconsin courts never award sole custody. That's not true. My name is Jeff Hughes and I'm the lead attorney for Sterling Lawyers. We are a large, exclusively family law firm here in Wisconsin, and we see hundreds of cases and judges every single month. And that gives our clients an unfair advantage. In this video, I'll reveal exactly what Wisconsin courts require to award sole custody, factors that could make all the difference between full authority over your child's future or years of ongoing conflict and compromised decisions. So, how do you win sole legal custody in Wisconsin? If you are seeking to be the only parent with legal decision-making authority, Wisconsin courts, they require compelling evidence to override this preference for joint legal custody. Now, there are some really common grounds, and some of these you're going to know about right away because they make all the sense to you, but there are some real common grounds where the courts have said, okay, yeah, that's enough for us to award sole custody to one parent over the other. So I'm going to run through those. Now, first one, and that is when there is a history of domestic abuse or child abuse. In some cases, both of those exist. Now, that is very powerful stuff because it is very traumatic for the victims in those particular instances. And we can't have one parent who's abused the other parent have decision-making after the divorce. That just, it doesn't work unless there is a complete turnaround in their life. And there's a lot of time to observe that their behavior has changed permanently. Okay, that's one of the first one. A second one is when there is substantial substance abuse that affects parenting. So you can imagine, right? One party has a struggle with drugs or really abuses alcohol, and this has a dramatic effect on their ability to think clearly and make selfless decisions for their child. A third, and I would say this is actually the most frequently occurring ground, is when there is a demonstrated inability of one parent to communicate with or cooperate with the other parent on major decisions. They are so stubborn, so difficult to deal with, and so protracted amount of time has gone by where it's just utterly impossible to have discussions with them. This is unfortunately all too common. And it is also something where you need to have an accumulation of evidence and third-party support and documentation to prevail in this, because the courts need to be really convinced that that's the case here. Okay, so know that. The fourth common ground is when there's one parent who just shows a pattern of undermining that child's relationship with the other parent. But you need a little more than that. Typically, I've found when you can show that there's been a long-standing, repeated pattern of conduct where that parent undermines the relationship between that other child or between the child and the other parent. Okay. And the fifth one is that when there's evidence that one party consistently makes decisions harmful for the child. That's probably been shown up in a couple of these other examples here, but sometimes they can fall out and stand on their own, okay? So know that those are the 5 really common grounds. And if you've got those, 1 or 2 of those that exist in your case, first off, I'm sorry to you. I'm really sorry to your child or children for that. But now you have an opportunity to go to the court, present evidence on all those things, and win the day for that to happen. However, simply proving that one of these factors exists isn't always enough. Wisconsin courts require you, as the parent seeking sole custody, to connect the evidence you present and testimony to the child's best interest. Now, that's the standard that the judges and the guardians and the social workers look at when making decisions or making recommendations. They look at the child's best interest. So let me give you a hypothetical. So if I can explain this in a way that makes sense, you can kind of connect that to other examples, right? It can be able to put in your facts in order to make the argument in your case. Now, let's say there's one parent, parent A, is seeking sole legal custody because parent B refuses to consistently make the necessary mental health treatment for their child. Now, parent A, you, rather than simply arguing that he's being difficult or she's being difficult, you need to document that and you need to connect it to a child-specific diagnosis or treatment recommendations from multiple providers if you can. Having just one person say it's good, but having 2 people say it, 2 professionals who understand, boy, that goes a long way in convincing the judge or the guardian ad litem. Also, you do need evidence that parent B consistently refused to consent to the primary medical advice involving your child, that you need to show that there's a connection there, that the other parent B, just, man, they kept refusing what the medical provider said that your child needed. And it is also important for you to be able to show that decision-making impacted your child's development due to the delayed treatment. Those all play into that, okay? Make the primary arguments be all about bad behavior, negative impact on our child. Because of that bad behavior, Judge, you cannot give parent B the joint decision-making ability here. That needs to be on me, because I can see what's going on. I can show that. I can prove to the judge that parent B's bad behavior hurt our child. Now, when you're preparing your case and you're going through the months that it requires, you need to document and document and document every instance where there's been a major decision that was stalled or prevented by disagreement. Document that, and do that honestly and thoroughly. Also document every time there's been the other parent that has made decisions contrary to the professional advice and recommendations in your case. Document every single time that your child experienced a negative consequence due to the decision-making deadlock or approach of the other parent. Judges are very receptive to evidence where you've made reasonable and repeated attempts to resolve disagreements before seeking sole authority. So if you're going in, you're like, Judge, I need sole authority, and I have tried, and here's all the times that I've tried, and I've tried to accommodate. I've been reasonable in my accommodations and my flexibility, and it just has not worked out. For those things, I'm asking for the significant step of sole custody. Now, as you're documenting and preparing your case and putting all the evidence together to present to the court, records from third parties, teachers, doctors, therapists, those are all very, very weighty, because it's not just your testimony, not just your records, not just your documentation, but it's third parties who don't have a parental connection to your children, but have an interested connection to your children or your child, okay? So getting their records, that's very weighty. Communication logs showing a pattern of behavior. So one strategy is to get an app and ask the court to require you and your soon-to-be ex to communicate via an app that keeps a record of all the communications back and forth. And you need to be disciplined not to communicate via text and email unless you have to verbally. Put everything in that communication log so you can show patterns of behavior. If you have any police reports or agency reports, get those. Again, those are third-party reports that go a long way in proving your case. Any detailed instances that show aggravated behaviors with dates, with times, with pickups, with drop-offs that impact the child care, those also, again, add up. It all accumulates. Evidence of your child's struggles tied directly to the other party's behavior or home environment. That's also very compelling for the judge to read and the judge to see. Now, there's one more crucial tip that so many parents miss, and that is in Wisconsin, our judges and our courts prefer mainstream, conventional approaches to child rearing. So if you're seeking sole custody because you believe in an educational approach or a medical approach or something along those lines that deviates from the norm, focus on how conflict over those issues impacts your child rather than arguing for the superiority of your approach. Don't get into an argument with the judge that your approach is better. Just instead put the focus on how conflict over these issues impacts your child. Now, I'm very sympathetic to those who don't follow the norm. I mean, I personally, in our family, we don't do what's normal either, because we have very strong convictions for what we feel is best for our children. I really hope those 5 tips were helpful to you as you go through your case and you fight for what's right for your children and sole legal custody. Winning sole legal custody in Wisconsin is challenging. You are facing an uphill battle, but it can be won, and it's possible for you to present your case effectively and win the day. And if you have found value with this video, and if you're preparing for a custody battle in your case, don't miss this next video right here, Preparing for the Custody Battle, Who Gets Custody. It'll give you additional strategies to strengthen your position and help you understand exactly what to expect as your case progresses. And I'll see you over there.